Members, I call Committee of the Whole on Bill 9, Healthcare Costs Recovery Amendment Act 2025 to order. We are on Clause 2. Shall Clause 2 on Clause 2, recognizing the member from Courtney Comox.
Thank you, Chair. Good afternoon, Minister and staff. So we'll move along on Section 2. Will this nullify existing contractual agreements in effect prior to this bill's passage?
Minister.
Thank you, Chair. No.
Member.
Thank you. I think we're all wrapped on Section 2.
Shall Clause 2 pass? Aye. So ordered. On Clause 3. Member.
So if we could just start, if the Minister and staff could just explain the purpose of removing the 6-month deadline generally, and then we can get into some more detailed questions. Thanks.
Minister.
Thank you, Chair. What this amendment does, is enable government, if government's not able to file, for example, if government is not notified and misses the existing 6-month window, then government has to file on its own, and that costs time and it costs money. So this really is about being more efficient and prudent with resources, and also just noting that actions can go on for years and years. So it's not uncommon that that an addition is made more than 6 months later. So 12 months or 18 months later, something like that. Again, really the intent here is to avoid having to file a direct action on its own for government, and enabling the existing process that's taking place and being able to be on that. Thank you.
Member.
So is the intent here a bit to give the government more flexibility to join ongoing lawsuits later than was possible before? And I guess under which circumstances does the government foresee using this flexibility?
Minister.
Thank you, Madam Chair. So, so again, in this case, it is a failure of when the parties fail to properly include government. They haven't notified and included government. There's a 6-month timeline, and if that's missed, then the court almost always permits government to subrogate, but it involves an application, it involves court time, comes at an expense of time and money. So what this does is extends the timeline so that the parties can repair their own pleadings. So this is not an action, it is the responsibility of the party to notify, but when they don't, we have a 6-month window right now. By extending this well beyond 6 months up until the time the court makes a decision, then it enables government to more easily be able to be subrogated as it should be in the first place, but the parties failed to undertake the responsibility that they already had.
Member.
So can you quantify how many claims have been lost or dismissed because of this 6-month window? Like, is it extremely common? Is there any information on that?
Minister.
Thank you, Madam Chair. I don't have specific numbers, but I can say that it's not uncommon that government has had to file a direct action to preserve its claim. And again, that comes at an expense of time and resources.
Member.
So what does the government expect to see in terms of increased efficiency in time frame and savings when these are avoided?
Minister.
Thank you. It's difficult to answer that question because we just can't predict exactly how many claims are going to come forward in a year or whether the parties are going to fail to notify government. So it's not possible to really put a fine point on that. Thank you.
Recognizing the member from North Island.
Does this change expose defendants to indefinite uncertainty or late-stage cost claims from government lawyers? And again, thinking about as well uninsured people, small business operators, mom and pop shop, who maybe aren't sitting in this room aware that this is happening.
Minister.
Thank you, Madam Chair. No, it doesn't. It again, this is about tightening up certain aspects of the legislation, enabling the clarification that's needed so the public understands, so that defendants and plaintiffs understand their responsibilities, and ensuring that there's a clear understanding of what an insurer is, what an uninsured defendant is, and again, this doesn't remove the fact, it changes nothing about the intent of the act in the first place, and that if action is taken against a company or an individual for recovering the costs of healthcare that are the result of their omission or their error or their wrongdoing, the defendant remains liable. Nothing about this changes that core fact.
Through the chair, if you don't mind, member.
Yeah, I would argue that point a little bit, since we're removing the time frame, which gives predictability to the defendant. Suddenly that time frame is removed, so I argue the opposite. It doesn't tighten it, it actually loosens it so that it gives governments a larger time frame to be able to continue doing what it's doing. The other question is, has the minister received feedback from the legal community regarding the fairness or predictability of the amendment?
Minister.
Thank you very much, Madam Chair. Thank you to the member opposite for the question. I just want to address the first statement that she made, because I think there may be some basic misunderstanding. And I want to be as clear as I can be that what by extending the timeline, what this does is really the opposite of creating uncertainty. It is allowing the plaintiffs the opportunity to correct their error, i.e. if they do not undertake the notification within the 6-month window, government has the opportunity to take direct action. This avoids that so that the defendant, in fact, doesn't have to face 2 separate actions taken. In fact, it makes it more efficient because government subrogated is enabled to be part of the court action that the plaintiff has taken against the defendant. And again, just to comment that the liability remains, that nothing about the timeline alters that fact. Thank you.
Recognizing the member from Court.
Sorry?
I forgot to answer the second question, the actual question that the member asked, as did we consult with the legal community? We did consult with the judiciary because ultimately this is about court process. So yes, we consulted with the judiciary. Thank you.
Recognizing the member from Courtney Comox.
So I guess what you're saying is that you don't expect any unintended consequences here that might in fact create more backlogs. I mean, this seems to put sort of a hard deadline. By removing that deadline, I understand that this allows the government the opportunity to join the suit at a later date when it's required. But doesn't this also remove the impetus on the government to act quickly, right? So could this not have the unintended effect of not, you know, sort of motivating them to file in a reasonable amount of time?
Minister.
Thank you, Madam Chair. So again, it is the responsibility of the plaintiff to notify government. And so what this does is remove the possibility of having 2 actions being taken against the defendant. But it always has been the responsibility of the plaintiff to notify. Thank you.
Recognizing the member from North Island.
Yeah, not sure if this question is from this section, but it's just for my own mind to clarify things. For example, in WCB cases, there's ongoing medical costs, sometimes years down the line. And having had this bill implemented, is this a similar situation where if somebody's injured and for life, is the insurance company therefore liable for that life of that person, for their medical care for that injury?
Minister.
Thank you very much, Madam Chair. Yeah, the member is correct. This isn't relevant to this clause, and this bill does not touch on or have anything to do with WorkSafe BC. I think I'll just leave it at that. Thank you.
Recognizing the member from Columbia River Revelstoke.
Thank you, Madam Chair. I think at this point, we're finished with section 3.
Shall clause 3 pass? So ordered. On clause 4, recognizing the member.
Thank you, Madam Chair. Just looking at section 4.1, subsection 1, it says, within 21 days after filing a third-party notice, in relation to a proceeding referred to in section 4.1 or 1.1, written notice of the filing must be given to the government by the party who filed the notice. Can I just get an explanation from the minister and staff, if I may, why they settled on 21 days being that optimal window, please?
Minister.
Thank you very much, Madam Chair. The existing, if the member refers to section 4.1 in the existing act, he'll note that there is a 21-day notice permit for several other things, and this is really just to be analogous with that. Thank you.
Member.
Could the minister just clarify, just for the record, like who specifically would make that that referral to the government within the 21 days? Is it the defendant? Could the minister just quickly clarify that for the record, please?
Minister.
Thank you, Madam Chair. Yes, it is the defendant that has to file that notice. Thank you.
Member.
Thank you to the minister for that, and thank you, Madam Chair. So just painting a quick picture here of, potentially, a situation where we have, I mentioned this in my debate speech yesterday, a smaller operator who's operating maybe a seasonally intensive business. They may not, I'm thinking specifically of, let's say, a guide outfitter. That's a single person or maybe a family business. And there is a claim made. 21 days may be a very strict timeline for them. These folks can spend at least a couple of weeks at a time remotely out of cell service, things like that, and they don't necessarily have the capacity to make that claim within the 21-day notice. So just wondering here if the minister could clarify missing that 21-day window, what are the potential consequences for the defendant for failing to meet that deadline?
Minister.
Thank you very much, Madam Chair. I just want to begin my answer by being clear that this bill, this proposed legislation, is agnostic to the type or size or seasonality of a company or a defendant. And that this really is, again, about the principle of who should pay for the healthcare costs in the case that someone is found to be responsible for injury by their wrongdoing or omission. And to the member's specific question, adding a third party to their defense is something that requires amount of paperwork and work to be done. What we are requiring them then to do is to file one more form within 21 days to notify government that they've added a third party defense. So to follow on the member's example, let's say a guide outfitter is sued by a participant in one of their activities for an injury, and the guide outfitter says, you know what, actually it wasn't our fault. We hire a contractor to run these outings, and so we're going to add the contractor to the defense. And they have to go through a lot of paperwork to do that. The lion's share of that is already done. So in this case, they would need to then take that one extra step, which arguably could be done at the same time of filing a form notifying government that that third-party defense has been added. Third-party defendant has been added. Thank you.
Member.
And thank you to the minister. I think that's a very fair answer, and I appreciate that. Just as far as that process goes, is there an avenue that a defendant could take to apply for an extension, if needed, to that 21-day window? Thank you, Madam Chair.
Minister.
Thank you very much, Madam Chair. No, there isn't a process for extending that 21 days. And I didn't answer the member's question previously. I think he had asked about what are the legal ramifications of failing to miss that. So I will say the deadlines are missed from time to time, or and there isn't a way to really describe exactly what would happen, because it kind of depends. It's a case-by-case basis of what the circumstances are. But ultimately, there's usually time for the party to repair its error. And, I think for the most part, that's going to be given the space to happen, to have that repair happen. But it is clear, and it will obviously be clear through the process, that the expectation is 21 days. Thank you.
Recognizing the member from North Island.
Yeah, just to comparing the tight deadline for the defendant versus unlimited deadline for the government. I think it's sort of unfair playing field here. Just a thought that maybe we should extend the deadline 21 days in the reality of, an injury, a serious injury, and when you're a business owner, is a very short deadline. So would the ministry have a consideration of extending the deadline in view of the fact that the government has extended their own deadline to indefinite, versus the defendant now has to claim within 21 days, which is, if you're running a business and you're busy, 21 days is not a lot of time to fill out a claim.
Minister.
Thank you very much, Madam Chair. Again, maybe just to clarify some misunderstanding, this is not about government extending its own deadline. This is about ensuring that government can be subrogated up until the time a court makes the decision, to avoid the situation of having to have two separate actions taken, i.e. government learns past a 6-month deadline and then takes direct action itself. So this is not government extending its own deadline. This is ensuring that the responsibility of the party remains that of the party up until that time the court makes a decision to add to subrogate government. And again, just coming back to the 21-day deadline for notification of a third-party defendant added, again, this is one form that is added to the mountain of paperwork that's already been done to add that third party to the action, and or to the defense. And I don't think, we're not expecting that's going to be an onerous requirement in any way, shape, or form. Thank you.
Recognizing the member from Columbia River Revelstoke.
Thank you, Madam Chair. Again, I know it's a mouthful. No, I appreciate that from the minister, and I know as opposition members we're about government efficiency, et cetera. But, I just, because there's no avenue potentially for a short window of 21 days to notify government as a defendant, particular to clause subsection 1, I'd now like to propose an amendment to extend that to 60 days, if I may, bring it to the clerk. Oh, thank you.
Okay, we are now going to look at the amendment and see that if, I better find my text. I don't remember. Okay, we are going to take a short recess at this time to get copies made of the amendment. I have 2:08 on my watch. If everybody could be back at 2:15, please, ready to start. Thank you.
Okay, members, we will call the meeting back to order. Members for who are online, you have a copy of the amendment in the chat. Got it? Okay. So we have an amendment to Clause 4, put forward by MLA from Columbia River Revelstoke. And I will move. Okay, I have found it in order, and I will recognize him to speak to it.
Thank you, Madam Chair. Nice to see you in the chair. Just very brief. I know it's just a clerical change here, very, very simple, and I'm not going to take a lot of time. I just think because there's no mechanism to potentially extend that notification, I totally get it that the heavy lifting of the paperwork has already been done, but I just think that 60-day buffer just provides a little bit of flexibility for the defendant to file notice with the government. That's all. Thank you.
Thank you, member. Minister?
Yeah, thanks very much, Madam Chair. Thank you to the member opposite. I'm going to speak against the motion and appreciate the intent here, but point out that the existing sections in the Act 4 sub 1 and 4 sub 1.1 already point to a 21-day notification requirement. And so to add a 60-day notification requirement for one part of possible action, which is the notification of a third-party defendant, is inconsistent and could create its own set of unintended consequences. I also want to point out that the BC Supreme Court civil rules, the time to respond to a claim is 21 days. This is a very tried and true period of time that is used for court action, and so we would not want to see stepping outside that. Thank you.
Any other members wishing to speak? The question is the amendment to Clause 4. Shall the amendment pass? Nay. I would say the amendment is defeated. So we will now return back to Clause 4. Shall Clause 4 pass? Aye. So ordered. Shall Clause 5 pass? Aye. Member from Courtenay Comox.
To the Minister, why must this be written and not digital?
Minister?
Thank you very much, Madam Chair. Thank you for the question. The form can be received digitally. In fact, the form itself on the bottom says this form is sufficiently served if scanned and emailed to the following address, and then supplies an email address. So for these purposes, that is considered written notice. Thank you.
Member from Courtenay Comox.
Absolutely fantastic. We're starting to see healthcare move away from fax machines, so I'm pleased to see it. Why must it include a copy of the third-party notice?
Minister?
Thank you very much, Madam Chair. Quite simply to verify who the third party is, what the circumstances are, and all the relevant information that will be required by government and by the court. Thank you.
Shall Clause 5 pass? Aye. So ordered. Shall Clause 6 pass? Aye. Member from Courtney Comox?
What exactly does it mean in this context that the government's right is subrogated? Sorry.
Minister?
Thank you. He's gone. Subrogation means that government participates in the action without having to file an independent claim. This entire act is about the fact that government is subrogated and the government participates in these actions. So to go back to an example we were talking about earlier, with an outfitter who names a contractor as a third-party defendant, if in the end it is found that that third party, the contractor, is the one responsible, then government is able to recover healthcare costs from that contractor. Thank you.
Member from North Island?
So how will this subrogation work in practice if the injured person doesn't sue the defendant at all?
Minister?
Thank you very much. If there's no action, no court action, then there's nothing that to be recovered. Thank you.
Member from North Island?
So why is the government granting itself automatic subrogation rights instead of requiring judicial approval?
Minister?
Thank you. The government is not ramping up subrogation rights. That subrogation is part of the act, is from 2009, from the inception and implementation of the act when it was brought into force, and remains the same. What this act does is amend certain sections of the act to tighten up, to clarify, and to avoid some of the procedural challenges that we've experienced since 2009. Thank you.
Member from North Island?
Can the minister table the estimated number of cases where automatic subrogation would have applied had this law been enforced since 2009?
Minister?
Thank you very much, Madam Chair. May I ask the member to please repeat the question? We didn't quite understand. Thank you.
Member from North Island?
Can the minister table the estimated number of cases where automatic subrogation would have applied had this law been enforced since 2009?
Minister?
Thank you. Subrogation always would have applied. So however many cases have gone through, I don't have that number at the tip of my tongue, but it is there, evident in every single case. Thank you.
Shall Clause 6 pass? So ordered. Shall Clause 7 pass? Aye. So ordered. Shall Clause 8 pass? Aye. So ordered. Shall Clause 9, member from North Island.
Oh, clause 9. Are we at clause 9 or 8? 9, yeah. So clause 9, as the definition of an uninsured defendant, and it allows the minister to request the insurer or an insured defendant to cooperate with the government to recover past and future costs whenever and however many times the minister deems necessary. So with uninsured defendant now bearing the same requirements as the insurer, how does this even the playing field? Insurers are often more sophisticated, and like we mentioned before, it's placing a heavy burden on the individual.
Minister.
Thank you very much, Madam Chair. The uninsured defendant remains in exactly the same position if these proposed amendments are passed compared to since 2009 when the original act was brought into force. So nothing, these amendments don't change that situation at all for the uninsured defendant, and I hope that helps to clarify.
Member from North Island.
If you can excuse my question, just a comparison with Bill 12 that was paused. And Bill 12 was the Public Health Accountability Bill, a much broader bill. And it was paused. And part of the reason was, I think, the business confidence was really impacted because of the unknown liability from government lawsuits for healthcare recovery. So I'm wondering, with this bill, and I'm not being a lawyer, do you think it might also impact businesses as well, that they might have some concerns here?
Minister.
Thank you very much, Madam Chair. No, I don't. These amendments, again, they're very technical in nature, and they really are to clarify definitions, to clarify roles and responsibilities of the parties, to enable the public to understand that better, but it does not change the underlying tenet of the Act around liability, which remains. Thank you.
Member from Boundary, Sycamine.
Milkmead, thank you.
I'll get it.
I know it's a mouthful. Thank you for the opportunity. I'm not sure that this is the right place for the question, but I wanted to bring it up. I come from the outdoor recreation sector in my previous hat, and one of the big pieces of work that we do as a provincial association in that role was providing insurance for our operating of our snowmobile clubs and other outdoor, including ski clubs, mountain bike clubs, all of those things. I'm just wondering with the uninsured third party, whether government would be pursuing recovering health costs from those organizations that are providing public recreation and nonprofits.
Minister?
Thank you very much, Madam Chair. The Act is agnostic as to whether it's a business, a person, a nonprofit, a big business, a small business, a recreation business, a retail store. The Act is agnostic to that. It is about, again, fundamentally about being able to recover the healthcare costs from a defendant who is found responsible for injury so that the taxpayers of British Columbia do not have to bear that expense. And again, this is what the purpose of the Act has been since its inception in 2009. These amendments, again, they clarify definitions, they tighten up exceptions, they make it more efficient through the notification process for government to be part of action and avoid some of the paperwork costs and time delays that could have happened otherwise. Thank you.
Member?
Thank you, Madam Chair. Yeah, just so the defendant could theoretically be a nonprofit club and or recreation group offering public recreation opportunities on Crown land in BC.
Minister?
Yes, it could. And if it is doing so, then it is the responsibility of the organization, be it a nonprofit, an individual, or business, to make its decision about what type of insurance it ought to carry. Again, when a party is found negligent, in the wrong, has omitted something that has resulted in personal injury, and those injuries incur healthcare costs. This is about fundamentally, again, the principle that it is the wrongdoer who should pay for those costs, not the government of British Columbia and ergo the taxpayer of British Columbia. Thank you.
Member?
Thank you. Just for clarification then, those groups also are provided insurance by the province. So would the province be basically going after itself for the medical costs? Because those nonprofit recreation groups with partnership agreements and park operators all have insurance through the province.
Minister?
Thank you very much. I can clarify that government would not pursue itself. Thank you.
Member from North Island?
So why is the government imposing notification and disclosure obligation on individuals who lack insurance coverage?
Minister?
Thank you, Chair. I think the simplest way to answer this is that the failure to have insurance doesn't absolve wrongdoing. Thank you.
Member from North Island?
So what are the records and information and evidence that now must be provided to the minister?
Minister?
Thank you, Madam Chair. I think this is clause 10, so I don't know if we want to pass clause 9 first, and then we can move to the member's question.
This is a clause 9. Oh, sorry, I do apologize.
Shall clause 9 pass? Aye. So ordered. Shall clause 10 pass? Aye. Oh, sorry. Yeah. Yeah, my fault. Member from North Island.
So I'll ask the question here. What are the records, information, evidence that now must be provided to the minister? Thank you for that. Thanks for allowing the opportunity.
I do quick. Minister?
Thank you very much, Madam Chair. So this clause, as the member has asked around what type of records or information or evidence might need to be provided, to be clear, this clause enables, through the future development of a regulation, the requirement to provide such information. But right now, there isn't anything that government intends to do, but this really future-proofs so that, again, should there be a type of information that is required, we don't have to go back through a legislative amendment to do so, that it's done through a regulation-making power. But to be clear, Section 11(2)A of the Act sets out the information or evidence related to the beneficiary's injury or health services claim that must be provided at the minister's request. And so this includes the nature and extent of the beneficiary's injury, treatment, condition and prognosis, rehabilitation, the cause and circumstances of the injury, and the healthcare services that that have been provided or may be required. Thank you.
Member from North Island.
Yeah, it seems open-ended a little bit when the regulation hasn't yet been specified as what is needed, and healthcare can be quite the. So the other question as well is who falls under the duty to cooperate with, and it's quote person assisting the government.
It's by your knee. Did your knee hit it?
It's under the desk, yeah. You might have. Yeah, of course. Short recess.
We'll take a recess for 5 minutes. Call the meeting back to order, and just to remind folks, we're on clause 10. Minister?
Thank you very much. The answer to the member's question about who falls under the duty to cooperate is the beneficiary or their legal representative. Thank you.
Member from North Island?
Under section 3.2, the minister may make information requests as often as necessary. What oversight exists to prevent excessive or intrusive demands?
Minister?
Thank you very much. Thank you for the question to the member. So, I mean, government takes very seriously when you're asking for information in cases like these, that you don't want to overly burden the people being asked. And so, obviously, we'll only ask for that information which is needed. And I do want to be clear that it is very defined, the scope of what kind of information can be requested to aid the action and the defense that's being taken, and that is strictly limited to the nature of the injury, the health care that has been applied in that case, and those pertinent details. Information is treated confidentially, of course, and it would always be government's intention not to abuse that ability to be able to require information, only the information that's necessary, and to do so as wholly and fulsomely as possible at that time. Thank you.
Member from North Island?
How will the ministry ensure compliance with privacy laws, including FIPA? And does the ministry plan to collect information via indirect channels?
Minister?
Thank you very much, Madam Chair. First of all, I just want to be clear that this is not part of this question is not part of the amendments that are being proposed today. I will quickly answer it, though, to say that the ministry, of course, takes those obligations incredibly seriously and is subject and obligated to follow FOIPA and does so, not just as part of this act, but as part of the ministry's entire actions. And I also want to just be clear that information as part of a court action is disclosed in litigation. So that is part of the process where information about a person's injury or the health care that they've received can become part of that litigation and openly discussed. Thank you.
Member from North Island?
You know, this section 10 does ensure uninsured defendant provide the same amount of records and information as imposed on insurers. There are potential case scenarios where, again, a small outfitter, someone is injured, and the person that is injured does not want to pursue liability. And at that point, what happens is and does not want to disclose their private information, medical information. That's the scenario I'm thinking about when I'm bringing this forward.
Minister?
Thank you, Madam Chair. Just to comment, if an injured person chooses not to pursue court action, then they would never have a need to disclose any of their information. Thank you.
Member from North Island?
So just to clarify my own mind, so if that person does not pursue legal action, the government does not proceed with healthcare recovery actions as well? Is that what you're saying?
Minister?
Thank you very much, Madam Chair. Government has a right to pursue action, but in practice, it's extremely unlikely if an injured person does not pursue court action that government does. Thank you.
Member from North Island?
Rare doesn't mean never, and there still needs to be protection for privacy for a person that has decided not to pursue legal action. Is there a way of making an amendment here? Would considering that scenario, which is a very real potential, and again, part of the unintended consequences of privacy of medical records being lost.
Minister?
Thank you very much, Madam Chair. I'm advised that this is that question is entirely outside of this act. Thank you.
Shall Clause 10 pass? Aye. Shall Clause, so ordered. Shall Clause, member from Courtney Comox.
Thank you, Chair. To the Minister, what is required currently to be provided, and what additional information will have to be provided based on these amendments?
Minister?
Thank you very much. This is a consequential amendment to Section 10. So I'll just quickly revisit the answer that I previously provided, which is the information around the nature and extent of the beneficiary's injury, treatment, condition and prognosis, rehabilitation, cause and circumstances of the injury, and the healthcare services that might have been provided or may be required. Thank you.
Shall Clause 11 pass? Member from Courtney Comox.
So how will the ministry determine what constitutes relevant information under these expanded powers?
Minister?
Thank you very much, Madam Chair. To clarify, this is simply adding the uninsured defendant as a person who would need to provide the information. This isn't actually about the nature of the information itself. And again, Clause 11 is a consequential amendment, consequential to Section 10, again, requiring uninsured defendants to provide the records or information. And while the existing provision already actually includes other person, it is important to really specifically list and enumerate uninsured defendants because the beneficiaries and insurers are enumerated as well in that section of the Act. Thank you.
Shall Clause 11 pass? Aye. So ordered. Shall Clause 12, member from Courtney Comox.
Could you explain why this section needs to be changed in this Act?
I recognize the minister.
Thank you very much. Welcome to the chair. Again, this is a consequential amendment. It is actually just pluralizing subrogated right to subrogated rights in reference to Section 7 and 8 of the Act. And so we already had a subrogated right to a beneficiary's claim, but we are adding a third-party defendant. We've talked about that already this afternoon. So this is a pluralization. Thank you.
Shall Clause 12 pass? Aye. So ordered. Shall Clause 13 pass? Aye. Recognizing member from Courtney Comox.
Thank you. Welcome to the chair. This section clarifies that interest is payable to the government, which is a change to this Act. First question would be, why is the government giving itself the ability to charge pre-judgment and post-judgment interest on healthcare cost recoveries?
Recognizing the minister.
Thank you very much, Madam Chair. So first of all, this is a normal part of litigation, and I want to point out that personal injury claims can take years and years to settle. So by doing this, government is ensuring that the actions we take are consistent with other kinds of civil litigation, and that interest is payable. And again, the reason that prejudgment interest is collected is to compensate a successful claimant for being deprived of the money that was owed to them, potentially for these years and years and years, between the time that the claim arose and the judgment is rendered. This is similar as to what is done in Alberta and Manitoba. It's not that this rule didn't already exist, it's that these amendments make it crystal clear that it does. Thank you, Madam Chair.
Recognizing the member from Courtney Comox.
So I guess with the possibility that the delays are due to government, is there any mechanism within this bill or these amendments that would pause that interest if the delay is due to, say, the healthcare delays in transferring documents, things of that nature? Or can you clarify when the clock starts ticking and when that clock stops ticking?
Recognizing the minister.
Thank you very much, Madam Chair. We're hard pressed to think of an example where government would be the cause of the delay. And in fact, if the Act is complied with in its entirety, then it's very, very unlikely that that would be the case. But it's probably worth pointing out that government doesn't have to seek prejudgment interest, and that should some extenuating set of circumstances apply, there's the ability not to seek that prejudgment interest. Thank you.
Recognizing the member from Courtney Comox.
Has the ministry modeled how much additional revenue this could potentially generate annually?
Recognizing the minister.
Thanks very much. I answered this question previously, but I'll give a short answer now. No, because the intent of these amendments is not to generate revenue. Again, these are to tighten some of the exceptions, to add clarification to definitions and the roles and responsibilities of the partners. And again, the fundamental principle of this act since its enactment in 2009 is around the fact that those who are responsible for, through their own wrongdoing or omission or negligence for personal injury, are liable for the costs that government incurred to care for the person who was injured. Because the number of claims will vary from year to year and the specific circumstances of each claim is different, it's impossible to predict what that would be. Thank you.
To the interest. Oh, sorry.
Recognizing the member from North Island.
I apologize. Thank you. Just a question related to the interest rates, because interest rates aren't clarified. Interest rates can be credit card-like interest rates, which are way above bank option. And again, I'm thinking of the uninsured person added now to this claim, so that can be a significant cost to the
Recognizing the minister.
Thank you very much, Chair. The Ministry of Health has no control over interest rates. And in fact, they are set by regulation under the Court-Ordered Interest Act and would apply to any circumstance of prejudgment interest across government. Thank you.
Recognizing the member from Courtney Comox.
So one of the unintended consequences here, because healthcare recoveries take priority as debts due to the government, will this reduce the compensation available to victims who settle claims?
Recognizing the member.
Thanks
Or
very-
minister, sorry.
Member and Minister. Thank you very much, Madam Chair. Just want to note, this is not part of this clause or part of the Act, in fact. Beneficiaries' interests always come first, so to answer quickly, if funds are limited, the priority is always the beneficiary. Thanks.
So shall clause 13 pass? Aye. So ordered. So shall clause 14 pass? Aye. Recognizing the member from North Island? Yes.
Okay.
Sorry about that, yeah.
We're all rusty, it's all good.
Sorry.
You're doing a great job, Deborah. Adrian's bringing cake for that, I heard in 10 minutes.
So the government must reimburse the insurer or uninsured defendant for the costs incurred complying with records requests, which on a record I don't think is a bad idea. I actually think it's a good idea. But has the ministry budgeted for this new indemnity expenditure? Meaning if they made 6.6 million for 23-24, you know, we're not talking big monies.
Recognizing the minister.
Thank you. Rarely, if ever, is there actually a cost associated with this. So, the amount is so inconsequential that it's accounted for within the ministry's existing budget. Thank you.
So shall clause 14 pass? Aye. So ordered. Shall clause 15 pass? Aye. So ordered. Shall clause 16 pass? Aye. So ordered. Oh, no, sorry, sorry. Recognizing the member for Courtney Comox. I was on a roll.
You're good. Welcome to the chair and congratulations. Why does clause 16.2.3 exclude several major sections of this act from applying to legal proceedings commenced before the bill's passage?
Recognizing the minister.
Thank you very much, Madam Chair. So big picture, this is a transitional provision that means the new sections of the Act do not apply to actions that are underway, i.e. not changing the rules of the game halfway through. But the reason why certain of the new sections are exempted from here, as the member is asking about, is because they are very consequential amendments. We spoke previously about pluralizing a word, that kind of a thing. Thank you.
Recognizing the member from Courtney Comox.
So is this clause intended to protect the government from liability for past administrative errors under the Act?
Recognizing the minister.
Thank you very much. No, not at all. This really is about orderly transition. Thank you.
Shall clause 16 pass? Aye. So ordered. Shall clause 17 pass? Aye. So ordered. Shall clause 18 pass? Aye. So ordered. Shall the title pass? Aye. So ordered. I recognize the minister.
Yeah, thanks very much, Chair. Well done on your first chairing experience. Thank you to the members opposite for the questions and the discussion. I just want to say a big thank you to the staff who've supported me throughout this committee debate. And with that, Honourable Chair, I move that the committee rise and report the bill complete without amendment.
Member, you've heard the question. Those in favor indicate aye. Those who oppose? Motion is carried, and this committee stands adjourned. Good afternoon, members. I call the Committee of the Whole on Bill number 10, Attorney General Statutes Amendment Act 2025. Shall Clause 1 pass? Recognizing the minister.
Thanks, Sarah. I just want to introduce my team maybe before we start that's sitting here. I just am grateful for the work that they have done to put this statute together, or the bill together, and it's from different areas of my ministry. So welcome to Anita Nzeko, Director, Policy and Legislation Division, Tegan Dean, Senior Policy Analyst, Adrian Rockwell from Pensions BC. We also have Isabel McIntyre, Senior Policy Analyst, and Taryn McKenzie, and Serena Tour, both Senior Policy Analysts. So thanks and welcome.
Shall Clause 1 pass? Recognizing the member from Richmond, Queensborough.
Thank you, Madam Chair. First of all, it's an honor to be back here in a fall session to have another committee stage of a bill with the Attorney General. And I also want to thank the staff that's here today, and I know you guys work really hard, and to kind of put this, there's a lot that goes behind preparing these bills and getting the bill ready for committee stage, so I thank you for your time. So in regards to Clause 1, I have some general questions about the bill. I know there's some latitude that is provided on Clause 1. So I'd like to ask some general questions about the bill, starting off. The main theme from the second reading of this bill was that, in principle, this bill was supported by the official opposition, but there were some concerns over consultation. And so I did state that in my second reading speech that we'd be asking consultation-related questions in the committee stage. So that will open up my first question. Can the Attorney General, through the Chair, can the Attorney General outline the consultation process used to develop Bill 10 in an overall manner?
Recognizing the minister.
Thank you, Chair. And it's your first day, so welcome to the chair for the first time. So I guess maybe I could ask the member through you, Chair, if we could do it from different section. It's just each section of the bill is made up of very distinct, not only statutes, but also stakeholders and what the consultation would be like. So I would say just generally at this stage, every I guess section of that with the different statutes had a different consultation process and different stakeholders. So maybe suggest to the member opposite if we can go through that as we go through the bill, because it might just be easier than describing it all at once.
Recognizing the member from Richmond, Queensborough.
The official opposition is amenable to that idea, Chair. So I'll just get into the Judicial Compensation Act that gets amended by this bill. And in regards to the Judicial Compensation Act, I understand the purpose is to adjust pension calculations for judges with prior non-judicial service. And the first question I have in regards to this, I guess I just asked it earlier as a general overall question about consultation, but in specific to the Judicial Compensation Act, the amendment from this bill, what consultation process was done?
Recognizing the minister.
Thank you. So as a principle of judicial independence in our democracy, it's very important that this process or anything related to judge compensation is kept independent and non-political. So as is the normal course of things, what happens is there's a commission that is set out to review judicial compensation on a regular basis, and it consists of 2 members that are appointed by government, 2 members that are appointed by judiciary, and then they jointly appoint 1 member. So there's a 5-member commission, and they receive submissions. And so people can, anybody who wants to, can submit, make a submission related to judge remuneration and compensation, but generally government does, and the association that represents judiciary does, along with whatever submissions. They create a report, and as is the case with judicial independence, and we had this debate, it wasn't a debate, but generally government accepts or rejects the report, is how it shows up, because we don't make determinations of compensation because it can't be political. So that was the process that led to this recommendation that you see before you. When we were drafting the legislation, we did do consultation, and so in the drafting process of the legislation, there's certain people that you would have to include in that, and that would be PSEC, the actuarial organizations that would know about the pension-related aspects of it, the judiciary, the Association of Judges, and Indigenous leaders, and I think that's the list of the people that were reached out to in the making of the legislation.
Recognizing the member from Richmond, Queensborough.
So just in terms of a clarification in regards to this commission, how often did this commission meet? Does it meet on a regular basis, or is it on an annual basis? And what's the frequency of the actual planning here?
Recognizing the minister.
Thanks. So it's every 4 years, and the next one's coming up in March 2026.
Recognizing the member from Richmond, Queensborough.
So the commission meets every 4 years, but how long is that process of consultation or the study period? Is it a year? What is the time period?
Recognizing the minister.
Thank you. So the timeline set out in the Digital Compensation Act, and so it's very clearly indicated once the commission's set up, they have a year from the date of the setup to deliver their recommendations, and then following that, as set out in that act, are the timelines required for government to respond. So it's very clear and transparent what that process is.
Recognizing the member.
Through the chair, the Attorney General stated earlier that the new commission time period is coming up. And so that suggests that the last commission rendered their report probably 4 years ago. So is that correct? Is my understanding correct?
Recognizing the minister.
Thank you. So this was I guess, a delay. So according to the legislation, every 4-year period, it would have been 2022. That was the last time the commission made the recommendations through the report that we're acting on through this legislation. But because of COVID, it was delayed. So we had a delayed report and a delayed, just the cycle was off of the 4 years, but it would start again 4 years later, so that would be March 2026.
Recognizing the member.
So the recommendations that we're looking at right now in terms of the amendments are the recommendations from 2022, correct?
Recognizing the minister.
So an important thing to understand about this process is that under the Judicial Compensation Act, if the legislature makes a decision not to reject, then the content of the recommendations prevail even over legislation. So although this it's deemed like kind of a housekeeping amendment because the changes have been implemented as a result of the legislative action of the Judicial Compensation Act and how it prevails. But the way it would happen in the timelines is the commission was in 2022, the report is a year later. So then we're talking like around November 2023 because it was delayed by 6 months because of COVID. And then it would have been the next opportunity that we had as a legislature to either accept or reject, and we have to be sitting for that. So those are all the kind of steps that were in between that. This current change that's in this clause has already been implemented. This is a matter of cleaning up the statute.
Recognizing the member.
So I understand there were recommendations back in 2022, or a report was done in 2023. So the next question is, if there were recommendations, were all of the recommendations adopted or some of them?
Recognizing the minister.
All of them.
Recognizing the member.
Okay, so thank you for that answer. I appreciate that. And there's a whole bunch of numbers and dates in this amendment. I just would like some clarification in terms of the dates and the percentages, why they are what they are. They're so precise. So when we're looking at clause 1, we have the date April 1st, 2018, and then we have the date January 1st, 1966. Can the Attorney General elaborate on those two dates and why those exact dates are chosen, and what's the reasoning behind that?
Recognizing the minister.
So this all gets very complicated very quickly, so I'm going to try to explain some of the dates in a holistic way, and that maybe will help guide the conversation if we go into other dates. So the whole goal of these changes were based on a recommendation that said that if you were a judge that had did public service beforehand, and you became a judge, you should be entitled to the same public service pension as somebody else, right? So these changes are to line that up, and so the public service, I'm not sure of the Act, Pension Act, there's a piece, pension plan, went through different phases of changes. And one phase of change was April 1st, 2018, and you see that date before you. So that phase of change, the reason for the change in the date that you see there is to align with that, those changes that were made at that time.
Recognizing the member.
So further in clause 1, thank you for the explanation. But further in clause 1, we have certain percentages. The first one shows up in 1B as 1.85%. Why that specific percentage?
Recognizing the minister.
So again, this was in line with changes. So if we think about it at a high level, it was to align this particular very small group of people with access to the same pension that they would have gotten under the public service pension plan. So at that time period on April 1st, 2018, as I mentioned, that rate of 1.85 was set by in that pension plan. So this is to align that amount. So it just goes straight from that time in 2018 to the percentage that was set by an actuarium, and that it applies it to these group of people.
Recognizing the member.
So also throughout this particular amendment under the Judicial Compensation Act, the reference is made to non-judicial service continuously. And so I think the Attorney General was alluding to public service under a certain plan, and that's what seems to be included in non-judicial service. But I just want to clarify that definition. What all is included in that particular definition of non-judicial service?
Recognizing the minister.
So it just as an aside, these are the people that I'm usually very sad to see go, because they go from the AG because they're lawyers, and they go to the bench. So we lose the talent in the AG, but we get the talent in the judiciary. So that's usually what's meant, because they are lawyers that go to the bench by the public service that they're doing. I guess only one.
Recognizing the member.
That makes sense, that definition makes sense. But then my next question is that if we have public service serving public servants and they go to the judiciary and now their non-judicial pension gets included, is there anything that is comparable that runs side by side with this for the lawyers that were practicing in private practice that got appointed to the bench? And is there anything comparable? I don't know if maybe some of them would have had pensions, or maybe some of them would not have had pensions. So is there something comparable there?
Recognizing the minister.
So they wouldn't, if it's a private practice, somebody practicing in that realm, it would be up to them to arrange their affairs to see what their pension plans would be in accordance with whatever policy, if they do have one. That would be their choice, but this is just for the public pension.
Recognizing the member.
Moving throughout this clause towards clause subsection C, or subsection C that modifies F. There's another percentage, 2%. Is that just taken from another comparison as well, just like we had 1.85 come from a comparison and parachuted in this legislation?
Recognizing the minister.
So just to point out that the effect of what this bill does is it repeals that percentage, so the C, and it adds the B. So it would replace that 2% with what is included in what is before the bill as 1B.
Recognizing the member.
Earlier at the start of this clause, the Attorney General mentioned some sort of actuarial analysis that was done. When we have calculations and when we're looking at pension, there is some fiscal implications. Can the Attorney General elaborate on that actuarial analysis that was conducted to determine fiscal implications of a change on this judicial pension plan?
Recognizing the minister.
Just to note that this is actually a very small group of people. My team informs me that there were kind of two analyses that would have been done by an actuary. So the initial one in 2018 obviously was not related to this because it was to do with the pension plan generally, and that's an alignment exercise then. So then the next part about it was when we made these changes to the amendments, we hired an independent actuary, and they reviewed the joint submission to determine there's no fiscal implication to government or our public pension plan.
Recognizing the member.
I am good with clause 1, so should I sit down and then wait for clause 2?
Shall clause 1 pass? Aye. So ordered. Shall clause 2 pass? Aye. Recognizing the member.
So, further to the questions around dates that I was asking in clause 1, we're now on clause 2. And there's a new date here, it says before April 1st, 2006. Could the Attorney General elaborate on that particular date?
Recognizing the minister.
Thank you, Chair. So same reasons as before. This happened to just be phase 2 of the process where the public service pension plan was changed. So this aligns that with that date.
Recognizing the member.
And then in clause 1, I also asked questions about percentages. And then in clause 2, there's also percentages. There's one at clause 2B, subsection E.2, 1.65%. And then there's another one at G.1, states 0.35%. Could I please get an elaboration on those two percentages?
Recognizing the minister.
Also an answer in line with the one I made before, which is that that would have been determined in the phase of changes in 2019 that was to the actual plan that we're just aligning.
Recognizing the member.
And also in this particular section, an age is actually referred to. In subsection G.1, we say that an amount payable under the earlier of the member reaching age 65 and the death of the member. So is that pretty standard? Like, I understand, like, 65 is pretty standard, but like, is that pretty standard in terms of looking at pensions?
Recognizing the minister.
I can't comment on the standard in the entire industry, but this is again an alignment exercise where we, at that point in 2019, as I mentioned what the phase 2 was, that was the decision that was made at the time for the public service pension plan, and this provision aligns those entitlements that were available there with these individuals to make sure that they are also entitled.
Recognizing the member.
We had some discussion about actuarial analysis on clause 1, but we're on clause 2, and we're talking about these other numbers here. Attorney General's response was that from the actuarial analysis that was done in clause 1 and the calculations, there was no fiscal implications. Is that the case in this clause 2 as well?
Recognizing the minister.
Yeah, I can confirm that. Also, there's no fiscal implications.
Recognizing the member.
So just on a first blush read of this act and looking at the pension and percentages and calculations and seeing that you're now including non-judicial pension, the natural inference that comes about is that there has to be some sort of increase in payouts. And so when I hear the answer that there's no fiscal implications, how could that be? How does that reconcile with the increases?
Recognizing the minister.
Just to start by saying these individuals also would have paid into the plan while they were in their non-judicial working days at public service. And then the second part of that is this just is a matter of really excellent plan management. So at the different times that the decisions were made, there was a surplus because probably good investment decisions in that pension plan and good management. So those are some of the things that lead us to say there's, or to that, from that independent analysis that was done to show that there's no fiscal impact.
Recognizing the member.
Now, just thinking about this situation where we have public service employees, like say from the Attorney General's Department going to the judiciary. But another situation comes to mind. What if somebody worked for they did public service, but they were involved with public service federally, or they were involved with public service in another province, but then they came to work here in public service. Would that be counted in non-judicial pension time?
Recognizing the minister.
So there's nothing about these amendments that speak or contemplate extra provincial public service and whether it's included or not. And that would be dependent on many factors in terms of outside of these legislative changes about the pension that was, the terms of the pension that that person was under and whether it's transferable or not.
Recognizing the member.
I believe the Attorney General referenced that there were recommendations made, and that's where all the changes came from. And so there was a report back in 2023. Is that something that gets tabled that the opposition can have a look at, or no?
Recognizing the minister.
Yes, as mentioned, the Judicial Compensation Act, because of the independence needed for the judiciary, sets out very clearly all of the steps that are taken when it comes to judicial compensation or any changes to it. And that includes the transparency aspect of it. So it's very clear that it's not politically driven. And so part of that is tabling that in the legislature and the timelines associated with that. So yes, it was.
Recognizing the member.
I think I'm done with this clause. I'll wait till next one.
Shall clause 2 pass? Aye. So ordered. Shall clause 3 pass? Aye. Recognizing the member.
So in regards to clause 3 here, another date, April 1st, 2022, that's different from 2018 and the other dates that have been documented. Can the Attorney General just mention what this particular date of April 1st, 2022 references?
Recognizing the minister.
Thank you. You've just identified phase 3. So that line is, or the member has, that time period is associated with the phase 3 of the original analysis that we were talking about, the changes that were made to the pension plan.
Recognizing the member.
Okay, and then going further, in clause 3B, referring to E.3, the number here is 1.95%. And I take it that's similar to all the other numbers. They were taken from a plan that's comparable, and they were just inserted in here, correct?
Recognizing the minister.
That's correct.
Recognizing the member.
All right. I think we are done with clause 3.
Shall clause 3 pass? Aye. So ordered. Shall clause 4 pass? Aye. Recognizing the member.
Okay, so clause 4 repeals and, substitutes the following clause here. Member is entitled to a reduced pension under subsection 1 and is entitled to receive pension. But anyways, going further, there's another percentage. It says reduced by 5% for judicial service, reduced by 5%. Can the Attorney General elaborate on that?
Recognizing the minister.
Okay, so I'll just maybe explain the purpose of this section, and that will help answer the question. So the existing section also contains the reduction of 5% if you retire pre-65. So it's a pretty common part of a pension plan that if you retire early, your payments are reduced by a certain percentage. So that exists in the current act, and what the bill proposes to do is to take into account non-judicial time versus judicial time. that's pensionable. So that's the reason for the changes, but that 5% was pre-existing. And now you'll see what in that subsection 2, a difference between judicial service. And then if you go down to C, you'll see non-judicial service. So it helps to align the non-judicial service with the pension plan, the public service pension plan for that time.
Recognizing the member.
There is a definition or a phrase in here, contributory service. And when we think about service, there's different capacities of service. Somebody could be full-time, somebody could be part-time, somebody could be on-call, casual, all that kind of stuff. So when we read contributing service, I would like to know what this definition includes.
Recognizing the minister.
Thanks. So the definition of this, or the understanding of what it means for contributory service, is in the public service pension plan rules. And I'm told that those rules set out, doesn't matter if it's casual work or whatever, if you contribute at any portion of a month, you get that month counted as a contributory service. And it's calculated like in that manner.
Recognizing the member.
Going towards the end of this clause, there is another percentage that's a little different than the rest of the percentages. In clause 4C, subsection I, refers to 6.2%. So I just take it that that number was also taken from a reference point, just like all the other numbers.
Recognizing the minister.
So as I was describing this section before, the reason for these changes is to line the non-judicial service with the public service pension plan. So that's the reason for that percentage under C.
Shall clause 4 pass? Aye. So ordered. Shall clause 5 pass? Aye. Recognizing the member.
So now we're getting into the amendments of the land, amendments to the Land Title Act, and we're in clause 5 here. So I asked a question earlier when we started the questions around the Judicial Compensation Act. I started off with consultation, and I'll ask the same question here, and this concerns changes to the Land Title Act. What consultations were had in regards to the changes to the Land Title Act?
Recognizing the minister.
Okay, so this is the list of organizations that were consulted. So of course, the Land Title and Survey Authority of BC, because these would be consequential to their operation. The Modern Treaty Nations were also notified, along with Indigenous leadership organizations.
Recognizing the member.
And as a part of that consultation, what were some of the concerns that they may have had that the government was asked to take into consideration for these amendments?
Recognizing the minister.
So no concerns, and just to put that in context, these actually are changes that will just make it easier. It aligns two pieces of legislation, our Wills and Estates Act with the Land Titles Act, and allows somebody who's a court-appointed administrator to interact with the Land Titles Act as long as they have the authority, and that's something they didn't necessarily have the power to do before, which is just obviously a frustrating thing.
Recognizing the member.
This refers to certain, there's actually two clauses in here. It talks about filing certified documents in this particular, well, I guess that's in the next clause. Yeah. Okay, so we're talking about filing certain documents, and the Attorney General said this would make the process a bit easier. But there's dates that come into context here in regards to pre-1947, and then there's issues about whenever you're looking at wills and estates, you're looking at dates, what periods of time are you referencing, and you're also looking at how complicated estates are, and so how old they are and how complicated they are, and so how do the changes in this provision here, and actually in this whole section, how do they reconcile complicated cases? Like, will these provisions be able to deal with the complexity of some estates? Was that a part of the consultation process, and were there any concerns?
Recognizing the minister.
Just to maybe explain this a little bit, the changes actually on the list of things we do to legislation extremely minor, and it was I think from the viewpoint of the legislative drafter and the team, just an easier way to put the statute together. So if you'll see, we repealed the clause that we're on right now is a full repeal of that. But if you go to the next one, and I'm sure we'll get to that, 6, it's added in that subsection there, and that's just for ease of understanding and composition of the bill.
Recognizing the member.
So I thank the Attorney General for explaining that consultation was had with the Land Title Survey Authority of BC, as well as Modern Treaty and Indigenous and groups. But like, I at a period of my time as a lawyer practiced a little bit of real estate law and filing documents at land title and all that kind of stuff. And I know even some little changes, they can really affect how you file things. And is there a reason why legal professionals were not consulted in the process, such as lawyers, notaries, and estate professionals? Because we have a list of 3 organizations that were consulted, but I did not hear that legal professionals and estate professionals were consulted.
Recognizing the minister.
So in terms of, I think that what the member's question is getting at is what would the front-facing changes, if any, to lawyers in the area? And the answer is there would be none. There was a situation that was occurring where there was a lack of clarity in the law when you don't have a probate or estate investment analysis. At the time, it was required to have that, or there was a gray area whether it was required, and so the Land Titles and Survey Agency had a workaround under a practice directive to just allow for a court-appointed administrator to be able to do things before they had those documents. And so on the face, from the lawyer's perspective, nothing would change. What it does is provide legal clarity to that practice directive, so it fixes the issue finally.
Recognizing the member.
All right. That's set for clause 5. Next.
Shall clause 5 pass? Aye. So ordered. Shall clause 6 pass? Aye. Recognizing the member.
So in clause 6, there's a couple of definitions here. Death of a will maker, and well, let's just focus on a will maker. Can I get elaboration on that definition? Is that taken from this Wills and Estates Act?
Recognizing the minister.
So yeah, it is a very interesting term. It's defined in the Wills, Estate and Succession Act, and it's defined to mean a person who makes a will. There you go.
Recognizing the member.
Thank you for that explanation on that definition. And then the next phrase is intestate. I take it that's from the Wills and Estates and Succession Act as well.
Recognizing the minister.
Also defined under the Wills, Estate and Succession Act.
Recognizing the member.
Okay, so we have discussed the state before, or earlier in clause 5, April 1st, 1947. I still don't clearly understand why we have this date in here. Was there a different situation on how land title operated before 1947?
Recognizing the minister.
So interesting thing in the law, and as Anita put it, which I thought really captured it, we change forward and not backwards when it comes to this stuff. So if you have died, or if you're the death of a will maker before that period of 1947, you would go, and apparently it does exist, it does happen, that somebody that's died that long ago, there'll be a state issue. You go back in time to the documents that were necessary during that time of that person's death. It makes sense on a paperwork side, because maybe sometimes the paperwork that was around now just wasn't used back then. So you kind of have to pin it in time. So that's how the law works, and I think that's just the way it is in this area.
Recognizing the member.
Another thing that comes to mind, in addition to the date in this clause, we have the use of the term application and application to register a transmission of land, and then we have the wordings filed in the land title office. Now, there's been great digitization of filings and applications with the land title office. So now, if we're saying that you got to register specific documents, are we talking about registering the physical copies, that's actual certified copies, or does this also, how does it address the electronic filing situation?
Recognizing the minister.
Just to start out, nothing in the proposed amendments will change the normal course of the Land Titles Act and how you would register and the methods of doing that. And so, of course, a lot of things are online, and I'm told with this one, it would be, you must do it digitally.
Recognizing the member.
So, to the latter part of clause 6 here, we have subclause B. What's the reasoning behind having subclause B here?
Recognizing the minister.
Can you maybe help us out with telling us which section again that you were referring to?
Recognizing the member.
Sorry about that, Chair.
It's okay.
So I was referring to clause 6, and then I was right at B, at the bottom of the page.
Recognizing the minister.
Okay, so this was a drafting choice to make sure there was absolute clarity about the effect of sections 269, which is about joint tenancy, and when there's joint tenancy, there's different requirements. So it's contained, as you could see in the changes under 6A.2, except as provided in the section 269, and then the drafters thought it was best for absolute clarity to also make that, copy that and put that in, I guess it would end up being subsection 6B, the one you're referring to. And then, so then that clause of 266(1) would also say except as provided in section 269.
Recognizing the member.
So, just the whole of this Land Title Act applies to the next two sections as well. I was told that consultation was had with three entities. But what led to formulating all these amendments? Like, why did the government decide to do them?
Recognizing the minister.
This was a request by the LTSA.
Recognizing the member.
And when did that request happen?
Recognizing the minister.
So the request was made in 2022, and just to mention before, we talked about how there was a practice directive in place that they had to I guess, outside of the legislative changes, remedy the situation, or at least handle it in terms of their operations. So, but that was when they made the request.
Recognizing the member.
Was there any report that was made by the Land Title Survey Authority in regards to the changes? Like, how did it happen? Like, was it a letter that was sent to the Attorney General's office?
Recognizing the minister.
They sent a letter.
Recognizing the member.
In that letter to the government, did the Land Title Survey Authority, did they mention why they were asking for that change? Is there a specific reason that prompted them to ask for that change?
Recognizing the minister.
As I mentioned earlier, there was a lack of clarity in the law related to what their practice should be for a particular requirement of documents or not, and with the requirement not being actually available to the court-appointed administrator. So they created a practice direction as a workaround, but they wanted us to do what we're doing right now, which is to make sure that the law was clear.
Recognizing the member.
Is the Attorney General aware for how long they were operating, the Land Title and Survey Authority was operating with a practice directive instead of a legislative provision? Does the Attorney General know what was the time period of just following a practice directive rather than having a legislative provision?
Recognizing the minister.
Okay. Just to clarify the background that this sits in, because I think it really points to why this is more of an administrative change rather than anything else, just to align our laws with what the practice was out there. The Wills and Estates Act was changed in 2011 to allow for a court-appointed administrator. We were, I think, aware, of certainly the letter of 2022 about this, the issue from the Land Title Survey Authority about that this was an increasing thing that was happening. The practice directive, what they did in practice was say, when you get your court-appointed administrator, the order from the court, they required in there a section in there that says you have the authority to do X or Y with that land. So the Land Title Survey Act used that authority under that court order to do what we're exactly adding to the legislation right now to make it clear that that was the case. So that's kind of how this has evolved to the legislative changes that we're putting in place.
Recognizing the member.
So the Land Title and Survey Authority was using a practice advisory since 2011. Is that is my understanding correct?
Recognizing the minister.
Just, I don't have the exact date on me, but the letter was 2022 when they identified the problem to us, so.
Recognizing the member.
Looking forward, say if there's further changes that are required, is there a plan in place to deal with the Land Title and Survey Authority to make sure they're being more proactive, that if there are things that are falling through the cracks procedurally, is there a plan in place so that they can let the government know faster and the legislative provisions can actually be brought to the House faster, and so there's less of a time where there's these practice advisories in place for the future? Is there some sort of a framework in place for that?
Minister.
You're welcome. So we are, I'm told, in regular communication with, well, I mean, all of those, where we hold legislation and there's an agency that's affected by it, that's a regular communication with our team. So I would also say that with the regular miscellaneous acts or bills that the AG brings forward over the years, oftentimes there's these pieces of like good governance, as you would say, to clean up statutes and make sure that any legal authorities are clear, even though, but there's also always an assessment of risk, right? So when we put our team into the most higher priority legislative changes, you think about that. What is the highest risk? What is the ones that we move on? And so this wouldn't have been determined to be one of those, but the important thing to say is that when they started to notice that this was something that needs to be changed, they communicated with us, and this is part of us changing it.
Recognizing the member from Richmond, Queensborough.
Through the chair, and welcome to the chair, first of all. Thank you. Yeah. And so I understand it's a procedural change. It's meant to make things easier. But there are some concerns, like throughout the province, there's places where there's not enough notaries. And with like doing filings at land title, it's usually people hire professionals. So according to the Attorney General, will there be a need for getting additional professionals involved in any way? Getting another notary to kind of deal with the change or anything like that?
Minister.
No, and again, just to make it clear, this will not be a front-facing issue for anybody because this was something that was basically lawyers or anybody or notaries or anybody interacting with the Land Titles Act will not notice a difference. This is about legal clarity.
Shall Clause 6 pass? Aye. So ordered. Shall Clause, on Clause 7, recognizing the member.
Okay, so clause 7 is a pretty long clause. Under it, it provides for section 266.1. Perhaps the Attorney General can just explain the inner workings of this particular clause or this section.
Minister.
So this is the key provision that brings into effect what we've been talking about on these amendments. So just to talk through it, the section 1A, the order that it refers to under section 103 and 132 of the Wills, Estate and Succession Act those are the sections that appoint that administrator that we were talking about. And then this next one is that the order would vest them in the administration, in the administrator title to the land or charge. So that gives the clear legal authority by that order. And then that's subsection B. And then when you go to 2, that is what the registrar would look at to see whether or not they would what they would need in order to know that that person satisfies the ability to do what they're asking to do, and that is the conditions set out in 1A, so the ones I just talked about. They have the proper legal authority to do so, and that they've correctly described the land or charge affected.
Shall Clause 7 pass? Aye. So ordered. On Clause 8, member.
So Clause 8 talks about amending by striking out sections 265 and 266 apply and substituting section 266. Can the Attorney General just explain this particular clause?
Minister.
Because of the removal of section 265, it's a consequential amendment to make that clear.
Shall Clause 8 pass? Aye. So ordered. Shall on Clause 9, member?
We're now into the amendment to the Libel and Slander Act. And we're at Clause 9. And just like I asked for the previous 2 acts that we were discussing consultation. And when the amendments were being made by the Attorney General's Department to the Libel and Slander Act, what consultations were had
Minister.
Okay, so the consultation was done with the BC Provincial Court, the Supreme Court, Court of Appeal, Court Services Branch, the Alliance of BC Modern Treaty Nations, First Nations Leadership Council, Métis Nation BC, and no concerns were raised related to that.
Member.
And what led and what precipitated going about to actually make these changes? What started the process?
Minister.
So this is also in the category of housekeeping and good governance, and it's to do with changes that happened to the Supreme Court Civil Rules in 2010. And as a result of those changes, there needed to be a whole range of consequential amendments that were mostly related to terminology, like a switch between, like this one, a writ, issue of a writ and a notice of civil claim. Notice of civil claim is the current one. So this provision was missed. It didn't have any consequences because it was changed in other areas. So this is just a matter of cleaning up that piece of legislation to make sure it's clear that it's a notice of civil claim.
Member.
I actually precisely remember when the changes happened in 2010. It's quite burdensome to switch from having writ of summons and statement of claims and then changing the process to have notice of civil claims. But that was quite long ago. That was back in 2010. We're now in 2025, 15 years later, and we're now making the change 15 years later. Is there a reason why we waited like 15 years to actually get this change done?
Minister.
Just to make it clear, there were a whole bunch of changes, as the member noted. It was a big change that were made, that were changing terminology. And as happens when we have really complicated changes, sometimes things are missed. And so these sections were noticed as not having the right terminology. And as often happens when you have miscellaneous statutes, you add these kind of changes to them. So it just cleans up the laws that we have in our province.
Member.
The Libel and Slander Act, it's our statute that deals with defamation law. And defamation law deals with, protecting people from being defamed, and also balances that with freedom of expression. And a lot has changed in regards to defamation law or defamation situations, especially in the last 10, 15 years, 20 years, with technology and a lot of online forums. There's community groups, like Facebook community groups. People just instantly post stuff. There's online reviews that happen. I know that there's a bill that we talked about back in Bill 4, we talked about online reviews. So a lot of that digitization is happening. And we're making one technical change here to the Libel and Slander Act. But at this time when the ministry was actually looking at making this change, Was there any further discussion, or will there be a further discussion to kind of look at this act more in a wholesome way? Because there has definitely been significant changes in the digitization world and how that affects this area of law.
Minister.
Yeah, I think the member raises a very important point, just to say that although this is contained in a very discrete miscellaneous bill that is part of the normal course of business to add these changes as regularly, we're always looking at broader changes to respond to the times we're in related to online harms. And I think recently I just introduced changes to the Internet Images Protection Act through a bill that I hope will go through the legislature that starts to address some of the harms. And I would say that there's a broad scope of things that we're not only are we working on, but we need to work on as a country. One of the things I've advocated for at the federal level is federal legislation that covers the whole country related to this stuff, because they have tools that we don't have at the province related to this. But yes, just to agree, there's bigger policy and legislative projects than the ones that you see before you that our talented group of people are undertaking all the time.
Member.
So going back to this Libel and Slander Act, and there was obviously some awareness that shed light to the government to actually make this change. Was there any further discussion about anything else that whoever was asking for this change, that there needs to be other changes as well?
Minister.
So this section is a bit different than the one we talked about before with the Land Titles Act. This was not something that I think people were asking for. It was just a matter of, like I mentioned, the regular course of business of us making sure that we're cleaning up these things that we find in our statutes.
Member.
I think the Attorney General addressed this, but I'm not quite sure. I understand it's a procedural change, technical change, and I just want to confirm, as a result of making this change, it's not going to affect substantive law practice at all.
Minister.
No, it won't.
Shall Clause 9 pass? Aye. So ordered. On Clause 10, recognizing the member.
Okay, so Clause 10 deals with Section 7, which amends and strikes out and substitutes. Can the Attorney General elaborate on this and just explain the clause?
Minister.
Again, it's a cleanup clause, and so you'll note that there's a change from striking out of the writ and substituting with notice of civil claim.
Shall Clause 10 pass? Aye. So ordered. Shall Clause 11 pass? On Clause 11. Member?
This clause seems to be quite self-explanatory as per my second reading speech. But I just, if the Attorney General could just elaborate on the explanation on this clause as well.
Minister.
So these proposed changes reflect a decision by the Legislative Management Committee to withhold the statutory authorized increase to salaries of members, scheduled to take effect April 1st, 2025. And so the amendments in here just bring the legislative effect to accompany that decision.
Shall Clause 11 pass? Aye. So ordered. Shall Clause 12 pass? Recognizing the member.
Okay, so this next clause affects the Police Act, and it does actually make a significant change. It's not totally technical. It involves it involves introducing a deputy civilian director, a deputy chief civilian director at the Independent Investigations Office. And so I have some questions in regards to that. The first question, like the ones on the other statutes, is what precipitated leading to actually drop these amendments in here? Was there a concern? Was there a situation where something had happened to a deputy and then all of a sudden didn't have somebody to substitute? What led to the situation of actually leading to this particular amendment?
Minister.
Thank you. So this is a very specific change that was related to a recent example where our chief civilian director wasn't available to perform the duties. And what we discovered through that is that the flaw in the legislation about appointing and acting chief civilian, or sorry, in this situation, the terminology is deputy chief civilian director in that situation. So it just clarifies that, or gives the legal authority necessary for the civilian, chief civilian officer to do that.
Member.
And to the next question, now understanding what precipitated a change, there was a situation where there was a substitute lacking. But in creating this position, what consultation was had with which groups, and what was the extent of that consultation, and what, as a result of that consultation, what was said, what was asked for?
Minister.
Thank you. So obviously this change was brought about because of a direct discussion with IAO and the needs that they have to fulfill their operational, the functions of their operation. That was the most important one. But we also discussed this with Indigenous leadership groups, treaty organizations, and the Ministry of Public Safety.
Member.
So now that we're adding a new position, which is the Deputy Chief Civilian Director, how will this position be filled? I understand that it's, what I read was it's going to be through Lieutenant Governor in Council, meaning that it's going to be done by Cabinet. That's my understanding. It's going to be, the appointment's going to be through Cabinet. But what sort of process will be involved? Will there be any public merit-based competition, or will it just be strictly somebody would be chosen?
Minister.
Okay, so our Chief Civilian Director is a very important position, and they head what is our police oversight agency. So it's very important that that position is led by somebody that is independent and has very strong qualifications. So it, like anything, there's a merit-based process and a hiring process to do that. And there would be also for the chief, the deputy chief officer, deputy chief civilian director, sorry. And so that would be part of the requirements, also what the qualifications are listed in the act. But the next thing to say about that is the reason that it's an appointment by the LG is because it helps to make certain that there's that level of independence for that position, and to make it clear through following those processes to get there.
Member.
What specific qualifications or experience will be required for this new position?
Minister.
So the legislative requirement set out is that they can't be a former police officer. So that's clear. The IAO works with the PSA to set out a job description, and that would be public at some point, but it would include a very rigorous, I'm sure, type of qualifications that would lead to that job. We've had some pretty stellar people in that role in the past that have had a very good experience when it comes to oversight and an understanding of the important role of police oversight.
Member.
So when a deputy chief civilian director gets appointed, and say, for example, something happens to the chief civilian director, and then the deputy chief civilian director kind of takes over, what happens in the succession plan? Does the deputy chief eventually just become the chief, and then you got to look for another deputy, or do you look for another chief and then put the chief in that spot and put the deputy back where the deputy was?
Minister.
So just to think about the different scenarios that the member brings up, just to explain the changes that we're making. So the first one is the appointment, or the appointment for a new position, and that would be the Deputy Chief Civilian Director. So that's an organizational change in the sense where there's somebody in the job that's a deputy at this stage. And then there's the appointment of an acting one, which comes up later, and the acting one was the problem that we were trying to solve initially to create this these changes, was that in the event that the the chief civilian director is unavailable, you could put somebody in place as an acting director. So those are two different things. The member asked about whether it's a temporary or permanent. So if you would say, what the bill would do is if the chief civilian director is not somehow unavailable for a long period of time, you could put in place an acting one. Now, if that became permanent, like there was something that happened where that person was saying, I'm leaving the job, I can't do it anymore, then it would trigger obviously like a different thing, which is the search for a new chief civilian director, and maybe that acting person decides to apply, but that would be a separate process.
Member.
So just going back to the, by default, the deputy would become an acting chief civilian director temporarily, and it would revert back unless, say, the deputy applied for actually chief civilian director position.
Minister.
Okay, so solving two problems again. So one is by having a deputy chief civilian director. The chief civilian director would have the authority to delegate things, so they wouldn't necessarily have to sign off on everything. So that creates like a structural change. And then in the scenario where the chief is unavailable for a temporary basis, you could appoint an acting. Those two people don't have to be the same people, the deputy or the acting, because the bill is not set up for that as an automatic thing, that the acting person would be the deputy. I mean, you could speculate that it's probably unlikely that the deputy wouldn't be the acting in that scenario, because they would have the right skill set and be embedded in the organization, but that is a choice that would have to come up based on the time that at that time.
Member.
If there was a deputy in place, and now we're talking about an acting chief civilian director, and putting that person there, how would the acting person be put in? We talked about putting a deputy chief civilian director in place, but where would you find this acting chief civilian director if it's not in the structure right now?
Minister.
Just to say that we're on clause 12 of this section, so it does come up later on, where I'm happy to talk about it when we get to that clause.
Member.
Okay, so what's the estimated budgetary impact of adding this role of a deputy chief civilian director?
Minister.
So the IAO is expected to manage within their current budget related to this. This is an organizational change and gives more different structure and authority, but they would manage within their existing budget.
Member.
since the Attorney General mentioned earlier, this would be an organization change to add the Deputy Chief Civilian Director position. Since this is an office, would this require additional staffing to staff the Deputy Chief Civilian Director?
Minister.
Just to make it clear that it's very important that the IAO operates independently of government. So although, we have communications with them and we make sure that they have the resources they need to do their job, I do not make their decisions related to staffing or who they hire or how they structure. This was a necessary thing to give legislative authority to certain roles. Because there are consequential decisions that the chief will make that have legal consequences that we need to make sure have proper legal authority in the act to do so. But other than that, I mean, they manage within their budget and make those decisions.
Member.
The Independent Investigations Office serves a very important role in British Columbia. Overseeing, the deaths that may happen as a result of tragic situations. It was mentioned earlier that the IIO would work within its own budget. And so if it's going to work within its own budget for a new position, will there be cuts somewhere else to the IIO to actually find money for this position if they're working within their own budget? That's an important point because the IIO actually serves a very important role.
Minister.
Thank you. So making sure the IO is properly resourced to do the very important investigations that they're tasked with is very important to us. And so they were given an increase of $2 million in 2023 to make sure that their speed to investigation and they had the resources they need. So it's something that is now, just to make it clear, and maybe something that I said already is that this is about a reorganization and giving a specific legal authority. So they're expected to manage within their budget, which has increased.
Member.
I appreciate the Attorney General told me that government, there is, the Independent Investigations Office is also independent of government. And so there is, there's only a certain amount of information that goes back and forth with the Independent Investigations Office. But can the Attorney General shed any light on, because we are adding a new position, of how adding a new position would actually improve timeliness, transparency, and efficiency in IIO investigations?
Minister.
So this is about improving their system to be better and more efficient by giving them the tools they need to do that. So for example, because of the way it was set up before these changes that hopefully go through, the chief civilian director had to do a lot of the things on their own. Like there was no delegation authority. So you can imagine that having that all on one person could create some kind of a backlog. With these changes, the chief can delegate to the deputy certain functions. That's very important in terms of getting their work done more efficiently. So we expect that this would improve their ability to do their job, and it was something certainly they've asked for. So,
Member.
So now, just to get into the crux of Clause 12 here, before we move in, So can the Attorney General briefly explain how this section works and what was the purpose behind this specific clause?
Minister.
There's a very discreet thing that this change for this clause does, and that is just to include the Deputy Chief Civilian Director in the description of the staff complement.
Shall Clause 12 pass? Aye. So ordered. On Clause 13, member.
For clause 13, if the Attorney General can just provide an explanation of this clause.
Minister.
Thank you. This is a result of a new drafting convention, and drafters are very serious about these changes. So this would be a change from using the number 2 to second.
Member.
So, so it's just a grammatical thing, like just with just using like the numeric number second versus just the written form of second?
Minister.
That's correct.
Member.
And so like, seems to be very technical and how this is just put in here. And so if we would have just kept it the same, would it have made any difference?
Minister.
It would have made a difference to the drafter.
Member.
Okay, so now we are getting into clause, oh, sorry.
Shall Clause 13 pass? Aye. So ordered. On Clause 14, member.
Okay, so now we're getting into clause 14 here, and it's a little bit detailed here. It refers to the Deputy Civilian Chief Director, Lieutenant Governor and Council. It talks about appointing this chief. We talked a little bit about the qualifications. It would be merit-based appointment. And we talked a little bit about how it shouldn't be a former police officer and a person who is currently may not be appointed. And then 3, the chief director may in writing delegate to a person appointed as the deputy of, so I guess the first 2 are pretty self-explanatory. The third one's sub 3 is actually fairly detailed, but perhaps the Attorney General can just explain the whole section, and so we can just understand it better.
Minister.
Thank you. So this enables the appointment of a deputy of the chief civilian director, and it sets out the requirement that it may not be a former police officer, and it also allows the legal authority for the chief civilian director in writing to delegate to the person appointed as the deputy the power and duty that they have, subject to any terms and conditions. And then on the acting civilian director, it clearly states that if the chief civilian director is temporarily absent, and the word temporary is very important there, because of illness or another reason, or if there is no chief civilian director, the LG can appoint a chief civilian director, and just the duties are given to that acting. And again, the person cannot be a former police officer.
Member.
Couple of questions. The first one, I guess, going back to, I asked this question about an acting deputy, and the Attorney General asked if I could wait until later on in a particular section, in terms of how the acting chief civilian director would be put in the position that they would be put in. I see here it says through the lieutenant governor and council. The first thing is it would come through cabinet, correct?
Minister,
That's correct.
member?
Sorry.
Thank you.
Can the Attorney General elaborate on that process? We went through a little bit of length talking about the Deputy Chief Civilian Director and how they would be appointed. We talked about qualifications and all that. What would be the process for Cabinet, keeping in mind that the Attorney General just told me earlier, there's a little bit of a distance between the government and the Independent Investigations Office. And there's only a limited amount of information that goes back and forth, and the government would like to keep themselves independent from the Independent Investigations Office. But here, we have a cabinet appointment, which is directly from the government. How do those safeguards come into play when the government's trying to keep themselves independent, but yet they're appointing a acting chief civilian director?
At this point, it's 5:41. We are going to take a 10-minute recess. I call this committee back to order, and Minister.
Yeah, thank you. So the question I think we left on was the balance to maintain the independence of the office, which is very important. So one of the ways you do that is by establishing clear authorities and roles in legislation. So that's done in a transparent way. So it's set out very clearly where the roles are. And it's generally the case that there's appointments are made by cabinet related to various things, but it's after a merit-based process. I'll just note that there's a very particular situation with the acting chief civilian director. So that's more of an emergency situation where you have there's been an absence for whatever reason and somebody needs to take on that role quickly. So it would probably be in that scenario that you wouldn't have the time to do like the merit-based process that you would do in any other scenario. But of course, everybody would see that that's it for a temporary time period that's set out in the way it's the appointment's made.
Member.
Oh, I thank the Attorney General for that explanation. So, do we know what different duties that, I know there's a separation between what the acting chief civilian director does essentially what the chief civilian director would do, but now we know that we have a new office that is the deputy chief civilian director office. But we were told earlier, well, this is a organization change, so the deputy chief is going to be doing some of the work as well. Do we know exactly what the deputy chief's going to be doing versus like the chief civilian director and acting chief civilian director?
Minister.
So in consultation with the IAO, the wording that's in here is with respect to the independence of the chief civilian director. So you'll see in, what number is this, 14, well, I'm looking at two sections here, 14.3. So it says that the chief civilian director may, in writing, delegate to a person appointed the power duties of the chief civilian director, subject to terms and conditions of a chief civilian director considers appropriate. So you could see that we give the discretion to that delegation to the chief civilian director in respect of the independence that they have.
Member.
Earlier, we talked about, consultation that was had, and then a request was needed, a position needed to be filled because it was a situation where nobody was there to deal with an absence of the chief civilian director. In terms of I know that that's the way that happened in the past where you had somebody missing from a position, but is there, and I know there's a certain level of independence between the government and the Independent Investigations Office, but is there a procedure, we talked about in some of these other acts covered by this statute, there's been like a commission, or there's been like some sort of committee, or there's been sometimes when there's something lacking, a certain government authority sends a letter. Is there some sort of mechanism of review that is available to the government to know what is going on with the Independent Investigations Office moving forward to make sure the office is functioning properly? Is there some sort of accountability or some sort of oversight or some form of audit? Is there like a commission, something like that?
Minister.
Thank you. So there's various kind of informal and formal ways that the question to what the member asked happens. So first of all, there's the requirements of an annual report that's published publicly. And then there's the Treasury Board oversight of financials that would happen with just like any organization that receives public funding. And that's through various mechanisms. And then there's also the informal side of it, which would be the communications that happen between my ministry and the head, the chief civilian officer. And also, I have made a point of having semi-regular meetings with them as the Attorney General. So at that point, they can tell me what they're experiencing, what's happening, things we might need to act on, of course, respecting their independence.
Member.
In regards to the report, I believe you said there's an annual report. What does that annual report have in it? Does that report talk about the infrastructure of the organization? Does that talk about the evaluation of the organization? What does that report have in it? And is that public? Is that report available and to the opposition as well?
Minister.
Chair, just through you, I think this question, although I understand the need for the member and the curiosity, is not related to the clause that's before us. If I'm happy to figure out a way to provide him information in his critic role related to the questions he's asking about the annual report, but I don't think it pertains to this clause.
Member.
I think what I was trying to get to the bottom of is in this situation, what we had was we had to kind of fill holes after the fact. It was a reactionary decision to fill a hole because the chief civilian director was no longer available. And so now when I ask a question about a report, I ask that question about the report so we can be proactive rather than reactive. So that's why I'm asking what is in the report. Would that help us towards the future, say, rather than dealing with a staffing issue after the fact, could we determine that this is going to be a need moving forward before we actually get filled with a void? So I'm being proactive here, and that's why I'm asking the question.
Minister.
Thank you, Chair. So I mentioned all the informal and formal ways that the communication happens between the two offices. What I will say pertaining to this particular clause is that the acting chief civilian director, it's likely not going to be something that would show up or be predicted through an annual reporting process because it's, as it mentions, it's because of a temporary absence because of illness or another reason, which leaves there to be no chief civilian director. So as happens with the course of life with people that are in positions, sometimes you get in a position where that person, something happens and they're not available. So that's not something that an annual report would be predictive of.
Member.
Okay, so next question I have on this particular clause, this type of position excludes a police officer from being hired or a former police officer. Now, when we look at police officers, sometimes we see terminology such as peace officer, and sometimes those are police officers. And now, when we're looking at policing, there may be, I don't know, there could be like bylaw officers as well. There could be intelligence officers, say, working for CSIS. So in this exclusion, does this pertain specifically? It cannot be somebody that is in a local municipal police force and maybe in an RCMP position, but it does not catch the other people, or does it, like, is there a broad inclusion of who a police officer is according to the definition in this clause?
Minister.
So yeah, the member's correct that in the narrow application of this provision, it's a member of a former member of a police service or the RCMP. It's not related to the broader, what's often a broader definition of peace officer, which contains more people.
Shall Clause 14 pass? So ordered. Shall on Clause 15, recognizing the member.
Okay, so clause 15 deals with 4 subcategories, A, B, C, and D. And perhaps the Attorney General can explain and elaborate on this whole clause, including A, B, C, and D.
Minister.
So this provision is just really to clarify the remuneration and reimbursement of expenses and pension entitlements for the Deputy Chief Civilian Director. So you'll see in the provision that it adds that title of Deputy of Chief Civilian Director to those entitlements.
Shall Clause 15 pass? Aye. So ordered. On Clause 16, member.
Can the Attorney General explain clause 16?
Minister.
So again, this is making it clear that the deputy would have the powers that are needed to perform their functions, and that includes the same powers that are given to the chief civilian director and the IO investigators, and that the powers, duties, and immunities of a peace officer, and that carries out through the jurisdictions throughout British Columbia. So that clarifies those.
Shall Clause 16 pass? Aye. So ordered. On Clause 17, member.
And similarly for clause 17, can the Attorney General explain what was the intent behind that as well?
Minister.
So this is something that the chief already had the power to do, is to appoint a civilian monitor to review and assess the integrity of an investigation. This just allows that to be delegated to the deputy.
Shall Clause 17 pass? Aye. So ordered. Shall Clause 18 pass? Aye. So ordered. Shall Clause 19 pass? Aye. So ordered. Shall Clause 20 pass? Aye. So ordered. Shall Clause 20, on Clause 21, member?
Clause 21 refers to the Small Claims Act. Maybe the Attorney General just can explain what precipitated that change, what consultation was had, and then maybe just explain what this does.
Minister.
Okay, in terms of consultation, the BC Provincial Court, who actually requested the change, the Court Services Branch, the Alliance of BC, Modern Treaty Nations, First Nations Leadership Council, and Métis Nation BC were consulted, and no concerns were raised by any of it. And basically, this is just a very specific housekeeping matter of removing section 56.3, that reference, which relates to a process that's no longer in use about issuing a notice of objection to a CRT ruling that is now needed to be removed.
Shall Clause 21 pass? So ordered on Clause 22. Member?
Okay, so the Clause 22 deals with the Wills and States Succession Act. Maybe the Attorney General can just explain what precipitated this change and what consultation was had.
Minister.
So there wasn't any external consultation required for this one because it's the members of the public and certain financial professionals have been reaching out about this change. Very small but an important thing, which is that the first home savings account as defined in the Income Tax Act was added, and it was needed to be added under the definition of benefit plan for the functioning of the Act. And you'll note that another change was that the regulation making authority, you see it right below, was moved to that section to make it clear that legislative change is not necessary. If there's a new benefit plan, you can do it by regulation.
Shall Clause 22 pass? So ordered. Shall Clause 23 pass? So ordered. Shall the title pass? So ordered. Minister.
I just want to thank the team that cycled in and out to give me their support and advice and all the work they did on the changes here. Appreciate it. Honourable Chair, I move that the committee rise and report the bill complete without amendment.
Members, you have heard the question. Those in favour indicate aye. Aye. Those opposed indicate nay. Said pause. Motion is carried. This committee stands adjourned. Beautifully done, you two. Well done.